I'm Don with the Law Office of Don R. Dennis Jr. My office helps businesses that are involved in complex business deals. The issue is this: when you sign an agreement, are there adequate protections to help you in the event things don't go as planned? And do you comprehensively understand all the terms in the agreement? As an engineer, experienced attorney, and certified privacy professional, I've seen all types of agreements. My office's motto is engage diligence, because I believe clients have the right to a responsive attorney that has the same energy for them from the beginning until the end. If you're looking for an attorney that's going to fight for you and not with you on your matter, contact my office at 213-455-0880. Hello, hello, hello. This is Attorney Don Dennis. I want to thank you for joining in to watch this. This is an educational broadcast in which our goal, as always, is to help everyone understand the law, protect their income, and not be taken advantage of in any business transactions that they're looking to engage in. No attorney-client relationship is formed between any viewer and my office unless there's a signed agreement on file. So I am Attorney Don Dennis. I am an engineer by trade, and I got my Bachelor of Science degree in civil engineering from Northwestern University, and then became an attorney by attending UCLA School of Law here in Los Angeles, California. So the goal tonight is to talk to you about a very somewhat tedious topic: website terms and conditions, privacy policies, the little hyperlinks that you see on any website or mobile application that you might visit. And the issue is, if you put one up on your website, if you put one up on your mobile application, is in fact it going to be enforceable? Is it going to be enforceable if there's ever a dispute? If there's ever just a question with your customers as to how you transact business, how will you know it's enforceable? And that's what we're going into, because just what you're going to learn tonight is just because you put it up there, it does not mean that it means anything. And if you think about all the time, effort, and money you can spend to make this happen, it really could be frustrating and annoying if when you need it to work, it doesn't work at all. So that's why we're going to spend some time going through a few recent cases, because it's great to have a business that you can operate online. Many people had the opportunity to really explore this and expand their online presence, whether it's through their mobile application, whether it's through their website, but a lot of people had the opportunity to sell to people all over the world. And during the pandemic, people were at home. So what else did they have to do besides watch TV or go on their phone and learn about new things, especially if they had the opportunity to learn about your business? So we're going to talk about what makes these terms of use agreements, terms of service agreements, and even your privacy policy enforceable. How does the law look at it? Let me give you an example of a situation. There are 4 high school kids, and these kids come up with a plan where they're going to, steal some candy and food and drinks and other little things they can put in their pocket from a store near their high school. So they say, look, one kid says, I have my license. I'm 16. I can drive. So I'll drive the car. You guys go in and do what you have to do. So the other kid says, all right, that sounds good. I'll go up to the cash register and distract the cashier so that while you guys are walking around grabbing candy, grabbing drinks, whatever you get, he'll be distracted so that we can get away smoothly. And they come up with this idea. And then here comes Friday, they run into the store. It's a little crowded. So they're like, it works even better. However, on the day when they're headed up there, one of the kids that was going to grab some items decides not to show up and changes his mind and says, I'm not going. I don't want to be involved in it. And he leaves the other kids hanging. Now, They did agree to this in advance. And matter of fact, just to show each other how solid they were, they said, you know what, we'll just write it down and all sign it, showing that we're going to have a pact, we're down, and we're going to follow through on this. So they go in and they get the stuff and they think they're slick, they think everything works out smooth, and they leave. And a week later, they're at school, minding their business, talking about it, laughing, and the police show up. And the police know exactly the guys that were at the store, arrest them, and take them down to the police station. And they found them because of the security cameras within the store that easily identified them. You know, they're high school kids, so they thought they were kind of slick, but they didn't figure out everything. So they had to spend money on, their parents had to get them out of jail. They had to spend money for that and whatever other fees that were related to that. So what they decide to do is, after they got done with all that, they got together, the three guys that actually stole from the store, and they said, you know what? We wasted all this money. Our parents took all of our allowance to repay the store and, get this situation straightened out. And if that other guy would have showed up, he could have helped us and we probably would have got away. You know what we're going to do? We're going to take him to Judge Judy. We're going to take him to Judge Steve Harvey or court because we have a signed agreement, and he broke that agreement. And we should get our money back that he cost us in doing this. So these guys write into the show and they send their stuff. And what do you think happens when they actually get to court? The court looks at them, laughs, chastises them for being so dumb, calls them idiots, tells them to get out of court. The contract is unenforceable. Regardless of the fact they wrote it down, regardless of the fact they all signed it and agreed to what they were going to do, it's unenforceable. And this may seem real far-fetched and seem real crazy. And you might be like, Attorney Don, why would you even tell us something like this? The reason I'm telling you this is because it's the same logic and line of reasoning. If you have terms of service on your website and you find out they're unenforceable because of some things you didn't do. And that's what we're talking about, because it does not matter that it's written down. It does not matter that someone could have went to the website and easily saw what you had going on if it's unenforceable. So the terms at the bottom of the website, let's just take it from the beginning. The terms at the bottom are a contract. They govern or they dictate what's going to happen if you're selling shirts, if someone's buying your shirts off your website, if you're selling consulting services, if someone patronizes your company to obtain your consulting services. The terms at the bottom dictate the contract between you and the customer. A contract is made in general with someone when you make an offer, they accept it, and there's consideration. What's an easy example? You go to a restaurant, your favorite restaurant. You walk in, they hand you and offer you a menu. You look at the menu, you see some things you want. Maybe you want some crab cakes, maybe you want a steak, maybe you want a baked potato, and you accept it by letting the cashier or the waitress know, hey, this is what I want. Please bring this to the table. They have said okay, and then when you're done, they hand you the bill, you pay. So you guys had a contract. So there was an offer, there was acceptance, and there was consideration because someone paid. Online, contracts can be formed in various ways. However, what people think they're doing sometimes to form a contract, we found as of recent, courts are not saying a contract was ever formed. Because yes, you might have offered your services because you have a website that displays even your menu and things that you do, and people may accept it. But how do you know people actually accepted not only your product or services, but the terms of the agreement that you put out there? So in general, there are 4 different ways contracts are typically laid out online on a website. You have a browse wrap agreement. A browse wrap agreement is simply when you go to a website, someone's scrolling around, and what you're saying to them is, well, the mere fact that you scrolled on my website, you looked around, you've accepted the terms and conditions or the privacy policy at the bottom of the website. So the mere fact that you just went there, we're saying you've accepted it and you agree to be bound by all the terms in that agreement. Now, as you can see, how many people actually scroll to the bottom of the website after they find something they want to buy and read those terms and conditions. The second type of agreement is a click wrap agreement. This is one of those agreements that pops up across the front of the website when you go there, and you have to actually check the box for that little statement to disappear. The statement that says, by coming here, I agree to your terms and conditions or your privacy policies. A lot of times nowadays, you don't see that language. You'll just see something saying, I agree to cookies. So what I agree to cookies means is as clear to you as it is to me sometimes, because it's kind of vague. The other type of agreement that you have is a scroll wrap agreement. Scroll, SCROLL wrap agreement, where you have to actually scroll down the website. And when you're scrolling, it opens up terms and conditions for you to look at. And you can't check I agree to it until you get to the bottom. A lot of times you might see these scroll wrap agreements on your cell phone or your mobile phone. So for example, they'll update their terms and conditions on the mobile phone, and you can't click I agree, and you can't go to the next page until you scroll all the way down to the bottom, and then it activates the button. You can check it and you can move forward. And lastly, there's a sign-in wrap agreement. This is kind of a combination of the click wrap and the browse wrap, where you go to the website and they want you to agree to the terms of condition, but at the same time you agree by typing in your name or typing in some other type of information, simultaneously you're clicking that button when you say I agree, or you're clicking done, or you're complete, or you hit the button. Sometimes it'll say continue. And what they're saying is basically you've scrolled and you had to click a button to say continue, and therefore you've agreed to it. However, the problem is in some courts in the country, they don't know if people really understand what exactly they're agreeing to. Do customers really understand that they're agreeing to the terms? Or do they think they're just signing up to move forward and progress through the website? So that's what the issue is. Now, what we're going to talk about tonight is a case that was decided just in the month of April of 2022 by the Ninth Circuit. And they provided a lot of guidance as to what to understand and what to look and what they look for when they're deciding whether or not someone that went to a website actually agreed to what the terms and conditions were. So here, what happened is there was a disagreement between a customer and the company. And the company said, look, you have a disagreement. You have to go to mandatory arbitration because that's what's in our terms and conditions. But the customer said, well, I didn't know that was in the terms and conditions. I never saw it. You never specifically told me. So how was I to know that? I want to go to court. I want to go a different route to settle this matter. So why might a company, before we move any further, why might a company put mandatory arbitration in an agreement as opposed to just letting customers go to court? Well, it might be cheaper. It might be faster for the company. They might be able to pick the arbitration agency that they'll use in the event of the dispute. So they might really craft and tailor that arbitration clause to their favor. Nevertheless, let's take a look at the exact So let's see here. This right here is the case. Berman versus Freedom Financial. And this is what the customer saw. So a customer visited the website from their desktop. And as you can see, and the reason that we're looking at this is because when the court is analyzing whether or not these terms and conditions are enforceable, they look at every single detail on the page where they were presented to the user. So if you have a website, graphics are important. The layout is important. What the court said is the company used large, colorful font to get the customers to sign up on the website. But the language, as you can see where the arrow is pointing, where it says, I understand and agree to the terms and conditions, and I don't even know if you can see that on your end, but if you can, look how small that language is. And it's in black font. I'm sorry, it's in tiny gray font. Look how small that is compared to where you put the zip code, bright yellow, where you hit I agree in green. And what does it say you agree to? I agree to receive daily emails. And then at the bottom it says, this is correct. Continue. The court pointed out the fact that the hyperlinks for terms and conditions and privacy policy were in small gray font. The part about the mandatory arbitration was in small font. Terms and conditions were underlined. Privacy policy was underlined. But as you look at this as a whole, what is most prominent? What stands out the most to a website visitor or user? I would say that the yellow at the top where you put in your zip code stands out. Where it says this is correct, that stands out. But in comparison to everything else, look at the size of the letters for confirm your zip code. Look how small that is. But when you see I understand and agree, that is extremely small and tiny. And that's what the court made mention of. Now, they also had a situation in this same case where another person that went to the website had an issue and they visited the website from their mobile phone. Oftentimes, the way a website looks on your mobile phone as opposed to the desktop can be completely different. Here, the court said after someone enters their name and their gender and their date of birth, you can see there's a big green button that says continue. But the language that says I agree to the terms and conditions, which includes mandatory arbitration and the privacy policy, look how small that is. Again, it's in tiny gray font. Also, the hyperlinks are in very small gray font. They're underlined, but typically when you see hyperlinks, you're thinking hyperlinks are going to be in blue font. Here, they're doing something completely contrary to what people normally expect. And so what happened was the company said those terms and conditions were not binding. That mandatory arbitration that you want is not binding on the user. The court said it's unfair to try to enforce contractual terms that people never intended to accept. How do you know people intended to accept this? Look how small it is. Look at the attention that you brought to it on this website. This is the problem. Now, you would think a company, a large corporation, would know to get this right, would know to make sure companies that have legal departments, attorneys working nonstop on their behalf would know to get this right. So our next case that we're looking at is Uber. And even Uber, as of January 2020, this year, 2022, found out that their terms were non-binding in the Maine Supreme Court. Here's the situation. In 2015, and this is what you can see is this is where you sign up to use Uber as a rider. So in 2015, a son helped his blind mother register for an Uber rider account. She never used the account until January 2017 when she went to go get a manicure. And after she got done, she needed a ride home. Now she had her dog, her guide dog. However, when the driver arrived, the driver refused to take her home. So the family filed a complaint against Uber. And in response, Uber said, okay, well, you have to go to arbitration because arbitration are in our terms and conditions. And when you signed up, you agreed to our terms and conditions. Therefore, that's how we handle the disputes. Well, Ms. Sarchi is her name, Sarchi versus UberTex. She sued and they made a complaint and they went to court. So when you go to court, this case went at the trial court level, the appellate court level, and it made its way all the way up to the Supreme Court of Maine. So what did the court do? They grabbed the page and they have a screenshot here of what actually the user saw when they were signing up for Uber. And they broke this down area by area to see how clear it was that people knew what they were signing up for. First of all, they said, look, the background of the screen is black. However, where it's time to enter the space where you want the credit card or debit card entered, that's white. That stands out. It really gets people's attention. In addition, directly under that white bar is bright blue text. The text is blue. The font is blue that says scan your card or enter a promo code. So where you want the payment information, look how that stands out. It's very clear. You can see it from a while away and everyone understands what's going on. However, keep looking a little bit further where the red arrow on your screen shows. And there it says in light, very light gray text, by creating an Uber account, you agree to the terms and conditions. And then look underneath the terms and conditions. That's in even more light gray text inside of a box. It's not underlined. There's no hyperlinks that are underlined in blue that you typically see that draw your attention. You can complete your entire registration and create a rider account without clicking on the hyperlink. So you don't have to go to this hyperlink to create the account. So Uber has no way of knowing that people actually have read this. And I'll just take a break for a moment. Please make sure you hit that like and subscribe button and the notification button so that you know when we go live. Also, I dropped the link in the chat. So if you have any questions or like to leave a comment or like to come on, just go ahead and hit that link. You'll be in the waiting room. Now, in 2016, so Miss Sarchi's son signed her up for a rider account, obviously in case of an emergency, in case she needed it in 2015. She never used it. In 2016, Uber updated their terms and conditions. And what did they do? They sent their users an email letting the users know, hey, we've updated our terms and conditions, and which is standard for businesses. If you have a company and things occur, you change certain policies of your business, you're going to need to update those terms and conditions to remain consistent with how you practice your business. So in 2016, they sent out an email, they updated it. However, there was no way that they had to make sure that people reviewed the new terms and agreed to the new terms. They just sent it out and hoped for the best. Now, the court looked at this way that people can sign up to become riders and to use the service. And they compared it to the website and the way someone signs up to be a driver. And they found some very stark differences. If you sign up to be a driver, the court found you have to expressly agree to the terms and conditions. You have to click a button if you want to be a driver for Uber that says, yes, I agree. And it's underneath a statement that says, by clicking below, you represent that you have reviewed all the documents above and that you agree to all the contracts above. Then after you click, yes, I agree. And it's a pop-up box with words after that screen, if you want to be a driver, and it says, please confirm that you've reviewed all the documents and agree to all the new contracts. And then it says, click yes, I agree again button. So the court said, look how clear it is that Uber knows how they can make sure people understand what they're signing when it's on the side of a driver, but when it's on the side of a user or a rider, they didn't take that same level of care. So that right there obviously weighed against Uber. So what the court said is what they're looking for is conspicuous terms, things that stand out, an uncluttered screen. They're looking for an uncluttered screen. When you have a lot of graphic and fonts and you kind of hide or it's kind of not as clear about your terms and conditions or your privacy policy, that makes for a cluttered screen. And then they want to see, did you have an explicit manner where people can show they agree? Do you have underneath, even if you do have a click wrap agreement or a box that pops up, does it say I agree or does it just say continue? Does it say I agree to be bound by terms and conditions or does it just say I agree to cookies? Does it say by tapping the button you agree? Or what exactly is the language? Does it say you have to click here to show you agree? Does that box stay up the whole time until people agree on the website? Or if they see it once, you have it set, or your website developer has it set that it will disappear because they have cookies and they know repeat visitors, so they take it down. These are important things to show that people agree to what you're putting out there. So the court noticed all of these things. They noticed that they didn't have the hyperlinks. They noticed that the distance between the notice and the button where you click is, look how far apart that was. So these are important things that you have to take into consideration when you're designing your website, because you don't want to go through, again, you don't want to spend money, go through all of this for it to not work. Think about it. You're spending money paying an attorney. The attorney drafts the policies. Then you have to read them to make sure that the attorney did a good job and that it lines up, more so that it lines up with all the things going on in your company. because sometimes attorneys don't know your current, or I'm sorry, your future plans, and it might not be included. So you want to work with the attorney, collaborate, and make sure everything's included in those terms and conditions and in those privacy policies. And then you want to make sure that your web developer, and then also you spent money with the web developer putting this all on the website. So why do all of this? Just to find out your terms of service or terms of use agreement are completely unenforceable. Now, so what happened? Obviously, I am quite certain that Uber's attorneys or whomever they hired to prepare this put together a dynamic agreement. I'm sure they had an airtight agreement. However, none of it mattered if it's unenforceable. So they were on the right track. They just were on the wrong train. You have to be right throughout the process from start to finish. Your attorney has to be able to advise you, look, this is what you need, and this is how it has to be implemented, because the implementation process makes all the difference. So what are some ways to ensure that if you're putting together a contract, it will be enforceable? That if you're putting together your terms and conditions or your privacy policy, that it will work? Well, one thing is to have a click wrap agreement or a scroll wrap agreement. Let's look at an example of a click wrap agreement here. And I'm not saying that all the terms on this page are the exact terms that you need for your business, but for illustration purposes, what you'll see is that in the background is the main site on a mobile phone, or on a mobile phone that you would see when you go to a company's website. However, right where it says privacy policies is a click wrap banner that has a bunch of text. And at the bottom, it says accept and continue. And until you hit that accept and continue, that language is going to be there. That's what you need. That's what we're talking about when we're saying a click wrap agreement. Because here, if someone says, I didn't know, I was not aware, you have clear demonstrative proof that in fact people were put on notice. So this is what we're talking about when we're saying having a click wrap agreement. And unless you can show that the customer that bought your product or bought your service on your website has actual knowledge of your terms of use, you will not necessarily have an enforceable contract. So we know in California, the courts look at it like that. In New York, they look at it like that. In Maine and many other states, they look at it like that all of the time. Now, another thing that courts say that they look for throughout the country that we've seen in various cases is that they want to know that customers had reasonably conspicuous notice. Yes, you put the notice up there, but was it conspicuous? How did your graphic designer, your website developer put it on that website? How clear is it? How likely is a customer going to see those terms and conditions? Are they buried at the bottom of the website? Is the font real small? Are the hyperlinks in blue? Does it just blend in like you saw in light gray font where it's very hard to pick up, very hard to follow? Are the hyperlinks underlined? Most people are accustomed, if you're looking at things, to see hyperlinks underlined. Are they underlined? If not, you likely will have some problems trying to prove that a customer was put on notice. In addition, is the language used clear and in simple English? It's simple to say, I agree. It's simple to say, I understand and I accept the terms and conditions. I understand and I accept the privacy policy. That one sentence inside of a click wrap banner or a scroll wrap banner can make all the difference. Next, courts look at, did the customer have to take any type of action, any action whatsoever to demonstrate that they not only read that they agree, but they showed that they agree? Did the customer have to click something? Did the customer have to hit a button that was prominent? Was there a banner across the front of that website or that mobile device or that mobile app that wouldn't go away until they clicked it? Were the hyperlinks there? How if it was a sign-in agreement where you have someone enter some information and then they sign in, agree to your services, do they have to click more than one time? Not just click yes, continue, but click I agree. So these are important things. If you want someone to be bound to arbitration, does it say I agree to the terms and conditions? Terms and conditions, privacy policy, and that this is subject to mandatory arbitration. Are people on notice about such important terms? I agree to the return policy, for example. I agree that this is a non-refundable product that I'm purchasing. How clear is it in that click wrap agreement? Sometimes, for example, when they do updates on Apple phones, they make you scroll to the bottom before you can get rid of that update on that screen, that pop up, and you have to click I agree. But you can't agree until you go to the bottom. So they can easily show if they had to go to court, you had to scroll through the entire agreement. Now, whether or not you read it is on you, but you can't say you didn't see it. You can't say it didn't come across your screen because of the technology they use to set that up. In addition, maybe you might want to insert initials in your agreement, like DocuSign. If you've ever used DocuSign, they make you initial at multiple places in documents throughout it. And by doing so, if someone says, well, I didn't see it, well, no, you can pull it up. Here are your initials right here on page 2. Here are your initials on page 3. Here are your initials on the middle of the page. And each time it says, I agree, I understand what I'm initialing. So these are ways to ensure that your agreements are enforceable if need be. Now, this is not an arduous task for a website developer or a graphic designer to put on your website or your mobile app. So don't be fooled and don't think, okay, well, it's too much work. It's so expensive. We can't do it. It can be done. And more importantly, it's your business. So regardless, if that person can't do it, find someone that can. Because if something happens and you have to go to court, most likely the graphic designer is not going to be there. The graphic designer or website developer is not going to be paying your legal fees. It's not going to be testifying for you. It's not going to be going through the process. So you have to look out for your best interest and the best interest of your company if you want to stay in business. Now, in general, what I'll tell you is you have to have an attorney that can guide you from the start with respect to the knowledge you need to successfully put together the contract to the actual implementation of the contract. You need someone that's knowledgeable on your team that can explain these things to you, because this is just part of the situation and issues that pop up when you're crafting terms and conditions. This is actually the tail end after they're already been completed. However, there's very important things that have to go in there just to make sure that it applies to your business. So don't be fooled and just grab any old terms and conditions off of a website and throw it on your website and think they apply. Because it may include things from other states that have no bearing on what you do. Or it may include other terms concerning products you don't sell and open you up to liability. And you don't need that. You need a specifically tailored and finely crafted policy that speaks to your business. In addition, you need to update your policy as your business grows. The same way that you see Apple and other companies continuously updating their terms and conditions and privacy policies as the business grows, as the laws change to stay current with them, you have to do that as well to make sure that you're compliant and to make sure you're best protected. Because what I described to you in those cases, we can go over them in just a few minutes, but the people that were in them were going to court for years. We're spending money for years. We're wasting time and effort that could have been avoided had they had this information that I'm sharing with you right now. So if you need an attorney, if you're looking for someone to give you wise counsel, contact my office. The website is dondennislaw.com. In addition, if you'd like more information on this topic, go to my web channel, my YouTube channel, and subscribe to the Law Office of Don R. Dennis. There's another video about tips about website privacy policies, also tips on terms and conditions and what you want to have in there, some very key points to help give you some guidance and further explain this, because it's important. My goal is to help you be informed so that you can succeed and continue to thrive. I want to thank you for joining. Please make sure you hit that like and subscribe button. And until next time, have a great day.